Ladies and gentlemen, as I begin, let me again echo my colleagues and thank the Evianides Foundation for their kindness in inviting us to this event and to the hospitality which they've extended to us. It is one feature of Greek life which I am very proud as someone whose ancestors came from this country, and it's one of the great traditions of Greek life, the hospitality to strangers and their kindness to us. Stephen had mentioned that we have something in common, and I had mentioned it to him. The fact that we were both old boys from Jesus College, Cambridge, to Jesuits. And the importance of that rang home to me some 20-odd years ago when I was in the St. Louis airport, and a man in clerical garb across a crowded waiting room on a snowy day when it didn't look like the flights were going to leave, screamed across the waiting room, "Are you a Jesus man?" And I thought this guy was some religious fanatic, and was particularly embarrassed when he started moving towards me. But then I realized what the issue was as he got closer, because I had over my overcoat a Jesus College scarf, which is very distinctive. It's red, black, and red, and very long, it keeps you warm. And it turned out we had something in common, because we had both been to this institution, which is now over 500 years old. And as Peter Lockman said, religion is something that keeps people together as a social force. Well, there are other social forces which actually give you some hope, because even if religions are intolerant, and even if old boy associations are intolerant, they're intolerant in different ways. And they offset each other, and they enable us to live in some element of freedom. Now, as the chairman has already noted, the how is the important issue here. And as we all know, to use another cliche, the devil is in the details. And there are lots of details and lots of devils. What would be an ideal arrangement if you wanted to have international environmental law? You would have, in my view, a rather detailed convention which would also provide for an administrative apparatus to provide regulations for dealing with issues which are not fully described in the document, the underlying document, and that's inevitable, because again, the devil is in the details. And you need to have some arrangement for some centralized review of what is done at the local level. And I presume that's the purpose of having an international court, which would deal not only with appeals from the administrative apparatus, but with administrative matters coming from the local jurisdictions. That itself is not necessarily an easy task, and it will expose the fact that there are different legal traditions in the world which create serious issues. They're already being experienced in the United Kingdom, where the types of broad rights which are described in the European Convention of Human Rights, which are defeasible for all sorts of social purposes, and when they come in conflict, let's say privacy and freedom of expression, are said to be of equal value. And even the dreaded Mr. Justice Eadie has agreed that freedom of expression is less free in the United Kingdom now that the United Kingdom has internalized the Human Rights Convention as domestic law rather than being something that applied to the UK if you appealed to the European Court of Human Rights, but was not directly applicable in the courts of the United Kingdom prior to the 1998 Human Rights Law. So that would be the ideal. What we have at present are all kinds of hortatory expressions. And indeed, even the Greek Constitution in Article 24 provides that the protection of the natural and cultural environment constitutes a duty of the state. The state is bound to adopt special preventive or repressive measures for the preservation of the environment, matters pertaining to the protection of forest and forest areas in general, shall be regulated by law. Alteration of the use of state forests and state forest areas is prohibited except where agricultural developments and other uses imposed for the public interest prevail for the national economy. Germany now has also a provision, Article 20A of the Basic Law, which provides that, mindful also of its responsibility towards future generations, the state shall protect the natural foundations of life and animals by legislation and in accordance with law and justice by executive and judicial action, all within the framework of the constitutional order. There are also hortatory expressions in a number, maybe 4 or 5 states in the United States actually, have provisions claiming to protect the environment and setting it forth as an obligation of the state. The problem is, what effect do these have as law, and what do you make of them? One certainly should not underestimate the ingenuity of courts. The German Constitutional Court has used based Article 2.2, guaranteeing human dignity, and Article 1.1, guaranteeing the right to life, to generate a fair amount of positive obligations of the state with regard to welfare rights. And indeed, even Greece has almost been affected by the German Constitutional Court when attempts were made to keep Germany from contributing some share to the bailout of the Greek economy in the last few months. So I do not know what will or will not develop using these hortatory rights either in Greece or in Germany. All I do want to say is that insofar as it puts on the courts the obligation to develop a workable regime, that raises serious issues. And it also raises the issue which is hidden from us, at least most of the time, namely that the organization of our court systems reflect very fundamental differences of approach towards the issues of government and the relationship among the various branches of government. Let me take the last point first. In the United States, as Bill Clinton realized, no money can come out of the government unless it's been appropriated. And it is also impossible for the government to borrow money unless it's been authorized. And the way Congress authorizes the government to borrow is by setting a debt limit. And when the debt limit is reached, the government has to shut down because the U.S. government operates on a cash basis. And when I was younger, periodically in the 50s and 60s, let's say when I first started practicing law, it was a political game where the Congress would often refuse to raise the debt limit and wait until the last hour or so before the government would have stopped operating before it caved. And there was one funny example, which I actually told John Harris about, involving C. Douglas Dillon, who was the Secretary of the Treasury in the early 1960s when John Kennedy made him Secretary of the Treasury. He had previously been Deputy Secretary of State. You know who the Dillons are. Not only very rich people, but they own Chateau Aubryon and La Mission Aubryon now, and several other vineyards, and et cetera, et cetera. But at any rate, they had reached the debt limit, and the country was about to default. And a friend of mine, who was his aide, said, "What are we going to do about it?" He says, "How much are we going to go under if, at least, let's see if we can get by today. How much do we need?" He said, "Well, 400 million. At that time, the law, and it still provides, is if someone borrows money that is not authorized, the Secretary of the Treasury is personally responsible for it. Nowadays, the sums are so large that only Bill Gates or Warren Buffett could even be engaged in this game. But in those days, 400 million, which is still a lot of money, even now it's a lot of money, but in those days I reckon it would be about 4 or 5 billion. He says, well, give me some time to think about it. So he takes out his checkbook, he looks at the figures, he says, no, I can cover that. Just barely, but I can cover that. So you go out and borrow the money so we can meet our obligations. As it turned out, they didn't need to, because at about 4:45, Congress threw in the sponge and said, all right, you can have the money. But that's an important issue, because, parliamentary government in England is really based on taxation issues to a large extent, as Parliament insisted on getting more and more powers. And of course, no taxation without representation is one of the slogans of the Americans during the War of Independence, as we call it, maybe a war of rebellion from the British side. And if you ever get to Washington, D.C., actually, you look at some of the license plates which say no taxation without representation, because the District of Columbia has no representation in the House of Representatives. So they have a person who is paid the same salary as a representative, but she, because it's a woman right now, but she gets no vote. So, but she can sit and hear the debates, and she has the privileges and the pensions and what have you that go with being a representative. So that's a serious issue which has to be confronted. Now, let's look at it also from the perspective of the courts. The courts function best when they serve as a means for implementing the law, for ensuring fairness, procedural regularity, and to varying extents, serve as a buffer between the state and the citizen. That's particularly true in the United States, and as Professor Nielsen pointed out, in the United States, where freedom is considered to be a key value. That's an important function. And the function can also be seen in what we consider the localism of U.S. law. For example, the insistence on jury trials, and not only in criminal cases, but also in civil cases. The extreme, I suppose, in localism is probably, I'm sure it's not the only state, but North Carolina is one of the few places in the world where if you are being prosecuted for a felony, your options are either to plead guilty or to be tried by a jury. There is no possibility of being tried by a judge alone in North Carolina and the United States of America. No possibility whatsoever. And the jury will consist of 12 people, and it must come with a unanimous verdict. All 12 have to agree. Otherwise, you walk out. Now, they can retry you, I suppose, because it's a mistrial. But generally, at most, they might try a person twice. If he gets acquitted twice, or if they've a hung jury twice, that's it. The other difference, which is universal in the United States, and used to be so in the United Kingdom, before under pressure from the European Court of Human Rights, at least that was one, I think, but our friend can correct me, motivating factor, is the rigorous application of the nebis in idem principle. Maybe as a result of A against the United Kingdom or otherwise, it is possible now, in some circumstances in the United Kingdom, for a person who has previously been acquitted in a jury trial to be retried. That is not possible in the United States, and I don't think the United States would ever enter in an arrangement where it would be possible to retry someone. Admittedly, in a world with many jurisdictions, and that's even possible in the United States, acquittal in a state court proceeding does not necessarily mean acquittal if one is